All right, team. Looks like it is 9 o'clock. If it pleases the chair, it's up to you to call it to order, and then we'll get after it.
All right. Just check it's okay. I'm on. Since Gary Clark is chairman, we'll call this meeting to order. At first, it's the notice of the May 22nd, 2025 meeting of the Board of Examiners for Land Surveyors has been noticed on the website since December 18th, 2024. This month's agenda was posted on May the 15th, 2025.
All right. Thank you very much, sir. Let's take a roll then. Jay Kaufman.
Here.
Gary Clark.
Here.
Kevin Martin.
Here.
Justin Raines.
Here.
All right, Chair, we do have a quorum. And also just as a reminder, as we typically do, there's the public comment period at the end of the meeting. It's right after new business before we adjourn. So for anyone that's online or anyone that's present, we just ask that you would please sign in or indicate so in the chat box so that we can recognize you and give you an opportunity to speak about those items related to the agenda. We've already done the meeting notice, so I think we are free to adopt the agenda. Is there any edits or questions in regards to that?
Motion to adopt the agenda.
Second.
We have a motion and a second. All in favor say aye.
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 Very well.
All right. Looks like the next item, or the agenda item, is approval of meeting minutes. This was from February 20, 2025, our last meeting.
No changes of note. I make a motion to approve the minutes.
Second.
There's nothing further. All in favor say aye.
Aye.
All right. Professional Society report. Do we have anyone from TAPS online?
Yes, sir. Good morning. Can y'all hear me?
Yes, sir. Thank you, Mr. Cleveland. Feel free to proceed.
Yes. Thank you for allowing us to have a spot at the table, and very, very much appreciate, as always, being able to attend virtually. As many of you are aware, we had our spring conference was March 6th through 8th. We had really good attendance. The last number I heard was close to 400 people were at the conference. Had great vendor participation as well. The cornhole tournament was a success for the Tennessee Surveyors Educational Foundation. Raised some much needed scholarship funds there. Should have some final numbers on the attendance and how much was raised for the association and the TCEF and everything. The Educational Foundation at the June 7th meeting for the TAPS Board of Directors on June 7th. Most of y'all are probably aware that Tennessee Public Chapter 178 related to property descriptions passed through the legislative process and is now law as I understand it. And on a side note, I'm receiving positive feedback from the last year's licensing law application process that was passed as Public Chapter 650.
Good deal. Thank you, Mr. Cleveland. Any comments or questions from the board?
Don't think so. Always appreciate your time, Jimmy.
All right. Thank y'all. Appreciate y'all very much.
Thank you, Mr. Cleveland. Appreciate that update.
Thanks, Jimmy.
Thank you.
Yeah, he touched on the, since he mentioned it, I'll just go ahead and sort of highlight that a little bit. The GPS and cleanup rules went to GovOps on last month, April the 28th, and the distinguished gentleman from Middle Tennessee accompanied us, Mr. Raines, there, your vice chair, and he delivered some testimony to the government ops as well, and was able to get that across the line. So that is effective, has been since May the 7th. Yeah. So that's good. That was a big lift, and we had a couple sort of backing up right behind it, so we needed to move that one. So we were very thankful. I know the industry was waiting on it too. So good deal.
And I believe they're online now, are they not? When you go to the website and go to rules?
Yes, sir.
I think they are.
Yeah. They move pretty quick over there, the Secretary of State's office. That's great. All right. Education report. You have that before you. We have 6 courses. Any questions or comments?
I believe Philip had sent out some additional information on Mr. Thompson's classes, survey pricing, and accuracy of the EDM. And I looked over that. I have a couple of concerns. One is where I think they're worthwhile topics and would count for an hour of continuing education. I don't believe either one of them cover enough in ethics or the standards of practice to be sufficient to fulfill that requirement of anyone. I also have a concern. I don't really have enough information in his syllabus about how he's going to administer this. It's just like it's a home study course, but as my understanding of our continuing education requirements is that there has to be some method or manner in which the student can interface with the teacher, ask questions, and be more interactive with that. And I'm not sure that I see that in this particular course offering.
Yeah, those, I don't have it in front of me, but the rules do vary from industry to industry or program to program. We do have some some industries or programs that allow for correspondence courses. Now, obviously, there's a control that's inherent to that needs to be demonstrated in their description as well. To where they're identifying basically that is in fact the person that's taken that course, and so there would be on that level there's always some interaction, But if he didn't detail that in their mechanism, I know right now the recommendation is for approval. But if we have questions, that's fine. We could take these two to the side and say for the rest of the report minus these two, subject more information, and so that he's not waiting until August. We could decide, hey, look. Should two members, just like we do an application review, if two members sign off and satisfied by the new information, then it's approved then. If that's the board's decision, we could go that route.
Well, it's more of where I'm leaning to. I say I don't have any trouble with the topics as far as being a general credit for continuing education, but I'm unclear. I mean, all the ones that we've looked at and approved before, my understanding the rules, it's it's either a live or it's a webinar, or even if it's a computer-based, that there is something like a ongoing quiz going through it that they track, that there's some back and forth, and usually there's a method of contacting and interacting with the teacher himself. So I would prefer to defer that until we get more information that he shows that he's meeting those requirements.
Okay, that's great. So do we just need that in the form of a motion? We'll say the motion would be if you approve that as I'm about to articulate. The motion would be approval of the education report, except for course number 1269 and 1270, subject new information requested, and should that information satisfy at least two reviewers, then it would be approved, signed off, and approved as well.
So moved.
All right.
Second?
All right. Got a motion from Mr. Raines to approve that minus those two courses, subject new information, and then automatic approval with two signatures. And then we've got a second from Mr. Kaufman. All in favor, please say aye.
Aye.
Any opposed? All right. Hearing none, then that is taken care of. Then, and then if Mr. Clark, I suspect you've already reached out to Phil, but Phil, if you haven't already, just coordinate that with the provider, and then we'll get that information and we'll sort it out.
Okay.
All right.
Phil, I'll put it. I'll send you an email with a more formal request on that. Detail it better.
All right. Thank you so much. All right. Let me get there myself. All right, looks like we're at the director's portion of the agenda. So budget is just informational only, and then we have one action item, just officially approving your attendance to that annual meeting. So the first item, let me just run over that with the budget with you guys. I highlighted a couple things just to make it easier on you because there's a lot going on there with the budget. So if I'm going to be talking about a couple items in the future, I'll probably just highlight it for you so you can find it. It's like looking through all the rows. At our last meeting in February, we covered the months through December. As a result, we'll focus primarily on the last 3 months of record, which were January through March. There was an uptick in Edison expenses under other. You'll see that there. In January, resulting from NCAAS membership dues. Anytime January is usually mid, if it's end of fiscal year for some organizations, but most organizations, January, we're paying membership dues. So you're going to see that every January. That was the uptick there. There was also a slight uptick in technology expenses. You'll see that in February, the following month there. I highlighted that due to enhancements to some of our online applications. So we're always looking for process improvements, and that's so ongoing, as we work through those, you'll see those expenses reflected. And of course, I'll always relay that when we do that. Since the end of the calendar year marks the end of our renewal period, we'll send out a reminder in the next few months while also pointing them to our link of pre-approved education. This just so you know what we're doing. We are approaching the end of our renewal year. And so I'd like to, if I can, just a little reminder, hey, by the way, you're approaching December, let's get that CE in, be working on it, and then sort of what the instructions are for that. We'll give them a link to our pre-approved education. And for those cases when the registrant acted in good faith and completed CE during the renewal period that was not on the pre-approved list, we'll continue sending those to a board member for approval as well per Rule 825.54. So, no, our process hasn't changed, but just nonetheless want to let you know that that'll probably be going out. So if you get that email, that's what that's about. I'm sure you'll be on the list. Any questions, comments? All right.
Hearing none.
All right, then move on to, I guess we'll move on to the 2025 NCS annual meeting. As you already know, New Orleans, Louisiana, that's August 19th to the 22nd. We'll be, during that conference will be happening there. I've already, let them know in advance. I knew we were going to have this meeting for, until now, and I know that we're straddling registration periods and all that, so we went and reported that, but we still need to make it official on the record. So we just need a recommendation for your attendance, and then approve that.
I think, are we allowed 3 members? Is that right?
Yeah.
And any other staff? Are they allowed as well?
I go just because I'm funded, and
Right.
I'm kind of like the baggage you check in. You know what I mean? I just go along. That's just how it goes.
Not
so,
sure.
Yeah.
Captain? All right, so I'll go ahead and make a motion for
Yep,
the
Lance
approved
Ferguson.
funding of 3 members and
Yep.
a staff member. Is that right?
That's right. Yep. Got a motion in that regard from Mr. Kaufman. Do I have a second?
Second.
I got a second from Mr. Raines. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none then, and I'll see you in New Orleans. All right. Looks like we're ready for legal.
Glenn, before we start
Yes, sir.
legal, could we maybe insert our visitor here and let him, so he doesn't have to sit through all this?
Yeah, I'm fine with that. We typically do that public comment section, but yeah, there's no reason why we can't pull an audible and then move them up. So yeah, Mr. Lawrence, please. Okay. We'll still have to do the public comment period at the end,
Be fine.
right? But out of respect for the person that's in physical attendance, we can certainly do that. Yep. Mr. Lawrence.
Good morning, gentlemen. I'm Sherry to put a face to the application. I hope if the microphone is on. My name is Matt Lawrence, and I just want to put a face to my application and maybe get a few questions answered while I'm here. It might be easier if I just introduce myself. Like I said, my name is Matt Lawrence. I started surveying back in 2018. While I was in college at Western Kentucky University, actually one of my surveying professors offered me a job while I was in his class, so that speaks to my character of the profession. 2019, I graduated from Western with a bachelor's in civil engineering, not surveying, since they didn't offer a surveying minor or bachelor's degree. I currently work for Reagan Smith right across the river, so it's kind of important I get my license in Tennessee. I've been there since July of 2022, and I've been pursuing a license since then. I think 2023, I first attempt to apply for a license or LSIT in Tennessee. I was told I didn't have enough credit hours. Being a civil engineering major, I've only had 12 credit list 1 courses per Western. That's all the surveying classes they offer. I took every single one they offered, and I've offered my course list to the board. And since I was told that, I went ahead and got my license in Kentucky, so I'm a licensed surveyor in Kentucky. And I still have my EIT in Kentucky and Tennessee, which I don't plan on pursuing engineering. I love surveying, so I want to stick to this profession. But since I do work in Tennessee, it's kind of important I get my license in Tennessee. And I just had questions about reciprocity. The code annotated says it accepts reciprocity, and then the Commerce website says you don't accept reciprocity. And then, and if I go the regular route, I have 36 surveying-related hours per the board, but only have 12 of List 1 classes. And I didn't understand that. It's several different locations are saying different items and different list classes, and it's just kind of confusing the whole process. So I just wonder if I can get some answers on that and some guidance or anything to get my license in Tennessee. Like I said, I took all surveying classes at Western at the time. I don't plan on going back to school. I can't really afford it right now. Tuition's kind of crazy, and I don't even know where to start on that. So if you have any guidance or answers to these questions or anything would be helpful.
Well, I think I'll start off with a question just because I believe I can understand the confusing between the various posts and the most frequently asked questions posts, and then looking at the rules yourself. I have some problems with myself some days with that, but I don't believe that we actually have a true reciprocity process in Tennessee without agreements with other states. It's really up to meeting what our requirements are, and some states, exceed it. And so if you have their license and your past hours, that some of them they have slightly different, and I believe that's the situation you are in. And you may be caught with, because lots of times folks who have been in it long enough can go the 10-year route. But since we just recently had legislations go through that modified that, they've now added the 18 hours of upper level class to that as well.
Which
So that may be where,
Can I chime in for just a second? Sorry to interrupt. I didn't mean to interrupt you. It seems like we're having the reciprocity discussion anyway. So if it pleases the chair, maybe we just do that piece first and just, have the reciprocity discussion. Because I know it was on the agenda for right after legal case report, and I wasn't sure what the issue was. I just, we knew we had a public comment, wanted to invite you to the podium, but now that we're getting in, it seems like this is a reciprocity issue. If you're good with that, we can just have that discussion on that agenda item.
I don't have any problem with that. Does anyone on that? So, yeah, I don't know that the reciprocity, I don't think, helps you out onto it. I think the real problem was that the change in the rules where there's no method of going without having at least 18 hours of the level 1 type courses. There's usually some confusion about whether it has to be on that list, which is, the list is really just ones that we have pre-approved, and it allows you, if you have coursework that is similar to that, we can compare syllabuses and see if we come up with anything. And I'm trying to remember if yours was one that I had seen, but it sounds familiar. Of course, actually, we hit that a lot. That just kind of preliminary right there.
If you like, I can read that statute to sort of just frame it for us, so then we can kind of just springboard off of it.
And I can jump in there too. whenever
Yeah,
you're ready
great.
for me, Glenn.
Yep. Sounds perfect. Thank you, Kyle. So TCA 6218-110 says any applicant may, in the absence of disqualifying evidence, be deemed by the board to be fully qualified to practice land surveying if the applicant holds a like unexpired certificate of registration issued to the applicant after examination by proper authority in D.C. or any state or territory in the United States in which. And then underscore this piece. It says examination and requirements for the registration of land surveyors are of satisfactory standard to the board. And so that's the reciprocity statute that Mr. Lawrence is citing. This portion emphasized does not mean universal licensure. It doesn't mean you have a license in another state, therefore we grant licensure. That's not how reciprocity works. There's various levels of reciprocity. Some do that, where if you got a license somewhere else. Good example is appraisers. They do that, but that's fairly regulated. So all the requirements are the same. That's why they do that. And CPAs right now, accountants, they're working through that. They accept across board, but because the requirements are the same, as soon as those requirements start shifting, now they're having discussions about whether or not they're going to accept universal reciprocity. So reciprocity doesn't mean you're licensed there, so you're licensed here. You still have to look at where you are on the spectrum of reciprocity and then make that determination. And then if some folks will state reciprocity as equal or greater, court reporters is like that. So the problem with that though is you can never enter in a reciprocity agreement with them because then you have to evaluate them every year. Because if you enter in with them today with a reciprocity agreement, and then your statute says equal or greater, they're equal or greater today, but tomorrow they might deregulate. And then now you're allowing a flood of court reporters across your border from, even though California, they had twice the requirements, now they've got none. And, so it's not just simplistic, easy to really manage. So I say all that to say, let's bring us to land surveyors, because that's what we're talking about. We're talking about land surveyors. And so, and then this portion emphasizes not universal licensure, but rather referring to the 5 pathways articulated in TCA 6218-109. And then Kyle?
Yeah, I'll just jump in to provide some quick comments and guidance. I think maybe the confusion is the statute says may, so it's really under the board's discretion whether they want to practice reciprocity, and right now, we don't. So that's completely your discretion. I agree this isn't really true reciprocity. True reciprocity is a mutual agreement between 2 states. It's not universal licensure, so we don't have any reciprocity agreements with another state right now. So right now, we don't practice it. I think this statute could potentially, if the board wanted to entertain it, allow for a kind of an application process where the onus is on the applicant to present evidence that where they have their license is the same or equivalent or more education requirements than ours. So it really still resorts back to 109. If a state doesn't have the minimum requirements that we do, then according to the statute, you guys would have discretion to deem that not standard satisfactory, which would probably be the conclusion if another state does not have the same requirements we do. So this statute really gives you a lot of discretion, and right now, with the may word, we don't practice reciprocity. I think it's something you could entertain in the future if we present some options, as far as if an applicant wants to identify that their state has the exact same or more requirements than we do, then we can put the onus on them. But it's just not a situation where another state that has less requirements than us, we would not deem that satisfactory, or my recommendation would be to not deem that satisfactory according with 109. So it's a lot of discretion here. What it boils down to is we don't have any reciprocity agreements. We currently don't practice reciprocity.
And if I understand what you said right there is, because the question is coming up to me before about the board having the discretion to evaluate the applicant's overall experience and education, but I don't see in the way that you explained it that there's any mechanism to allow type of experience or amount of experience to replace an educational requirement.
And that's what it boils down to. There's some other wording in there that holds a like certificate standard satisfactory to the board. So by statute, the satisfactory to the board is the requirements in 109. A like certificate would be equivalent requirements. So we could look in to see if you have any discretion there, but according to that language, I think it would have to at least be the minimum standards that we accept.
Thank you. That was my understanding of it. But I guess that's why we also have it out on the table to see if we need to.
Yeah, and as far as process, Kyle mentioned that because we don't have reciprocity agreements, like mutual, we don't have memorandums of understanding or mutual recognition agreements or anything like that signed and sort of memorialized with other states. So, and because they change all the time, the only way to handle that would be like an application review. They would have to show you that, yes, what I'm offering here is equivalent to 109, which is our statute for licensure. Based on where I'm coming from. Here's my qualification. And then 2 reviewers, do it basically like Ohio does. That's how they handle it. And so that would be our process. That might be my recommendation for our process. Right now, we don't have a process. We'd have to make a decision on that. But I don't, that seems like the most straightforward, process in handling that, like you would any other application review. Yes, here's where I meet 109, and here's the equivalency, and then 2 reviewers deciding yes or no.
Okay.
And I think the ultimate benefit, if you wanted to entertain something like that in the future, would be that they don't have to present as much stuff with the application. All they have to, as far as the requirements, what they have to present, that at the time they gained licensure in this state, those requirements were the exact same or more as ours. And so they don't necessarily have to provide all of their records and stuff like that. What they're providing is that, or what they would provide is that the requirements of that state at the time they gained licensure were the exact same as ours or more.
Right.
I don't know if listening on that helps or not on your case, Matt. Thank you for we brought you up. We didn't really think about dropping the rest of this stuff on you as well. Thank you for your patience. Jay,
Yeah, if
you
I
had
could,
something?
Mr. Lawrence, number one, thank you for attending and, I mean, having the guts to come and take time off work and show up here and pose your questions. So kudos to you on that. Let me try and answer your question. I think that you approached the board, and this is not an official answer. I don't have a review of any application, just based on what you've
Yes, sir.
told us today. So you've got the civil engineering degree, so that would qualify you under the Category 2
Category 2.
application,
Yes,
which
sir.
requires 24 hours of surveying-related courses, right? 18 of which are those upper-level courses. If I understood you correctly, you believe you have 12 already, so you're lacking 6 of those upper-level courses. I can tell you that generally in my review of civil engineering degrees, applicants, of which we have many, similar to yourself, that usually those extra 6 above and beyond the 18, 6 to make the 24, are usually incorporated in that civil degree somewhere, somehow. Mostly. I'm not saying you're specific, just mostly. So I think, and then as far as experience goes, sounds like you've got 2+ years with Reagan Smith, maybe some summer work as well.
Yeah, like I said, I've been surveying since 2018
Okay.
in Kentucky.
So it
and
sounds like
Tennessee,
you've got
so,
the experience. You're good there. The examination, I assume you've passed the FS and the PS because you have the Kentucky license already.
I've passed the FS, PS, and the Tennessee
And the
State.
okay, so it sounds to me like the only thing you're lacking right now is on the education basis. Again, I don't have your transcripts, and specifically about 6 upper-level courses, which are offered at places like ETSU. UT Martin is what I would suggest because it's close, although you can do it completely online. Their website is excellent on UT Martin. It outlines exactly which courses that this board has previously approved. Just make sure you don't duplicate. I would suggest that before you take the courses that you contact the board and say, I plan on taking these, just verify that they're acceptable. And short of making application, I think once you get all that together, it sounds like you're really close, just short on education. So does that kind of help answer the question that you were posed to us?
Kind of like I said, the board's already said I had 36 surveying-related classes, and not, like I said, I'm not missing the list 1. I was confused because it's not in the code annotated as a suggestion for the list 1 classes, so I didn't know if there's any leeway on that or.
No, we're pretty strict as far as all 5 categories now. We've got, as one of the common factors, being at least 18 upper-level courses. So that's number. The first thing I'm looking for is to make sure you've got those 18 semester hours of upper levels. So if you can knock those out and make application, it sounds like you may have your bases covered.
And if I may, Jay, I mean, to clarify, yeah, it's not strict in the sense that you have to take from that list, but if you got the classes from somewhere else, you'll need to send us enough information that we can see that it does fall within what we were intending in the upper level. The upper level is really the thing to that. And like Jay said, it may be that you have those hidden somewhere in your engineering courses, but when you just send us the syllabus, all we've got is the name and the number. And we do on occasion just make calls ourselves and see if there's anything in there, but you may be able to dig up out of those courses something that hits the intent of the courses on the list. And that's more of what the list is for, is to show you what we're looking for in class work that we would consider upper level.
Yes, sir. I think that answers most of my questions. So, thank you.
And let me reiterate what Jay said. If you have a question or before you take one, or if you think of your course that you've got, submit it to us and let us give you guidance before you go into it.
Yes, sir.
You may be able to, out of what you already have in civil engineering, find some hours.
Well, thank you.
Thank you, Mr. Lawrence. Since we're on the, no, I said thank you. I appreciate that. Thank you for addressing them and coming out too. I know, like to Kaufman's point, it takes real courage to do that, and also appreciate personalizing your application too. We always like that too. So thank you for doing that. So we have a decision to make just on process, and I mean it's more technical than anything else, but not on this application, but just reciprocity in general. We understand that we don't exercise reciprocity at this point, but 109 is our standard, has been, continues to be. But if you have somebody that could make the argument that they have like requirements, they can present their requirements at the time of their license in the other jurisdiction, and if the onus would be upon them, obviously, to make the case that it's equivalent, and then we would just treat it like a regular application review. So if that's the will of the board, as far as process goes, that they would present those qualifications and 2 reviewers would make that determination. We just need a motion in that regard. as far as
moved.
process. Yeah.
So moved.
All right. Got a motion from Mr. Kaufman. Do we have a second?
Second.
Got a second from Mr. Raines. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none. I guess without that's done, then we can move on to, unless there's anything in new business, we have a legal report. And while she's getting her paperwork, one thing we're going to shift, try something a little different. We're just going to introduce basically, I know you guys read the report. It's very technical, and all of it's going to be memorialized in the minutes. And so she's going to read the allegation, the findings, and then her recommendation, and then pause for your questions. And then we can read the entire thing if we need to, or we just get into the highlights and vis-a-vis your questions. But again, that'll be all posted. The entire report will be reported on the website once we approve those minutes after the fact.
It's worth a try, I believe. But
Yeah, we'll see how
I'll
it goes.
point out is that the highlight of my trip over here from Knoxville is always listening to Erica go over these reports.
We'll have her do some audio.
She
for
does
you.
it so you do it. You really do it well. And
So this is not a sarcastic remark. Well, I will just take that as a compliment.
We'll have her do some voiceover for some audio books on your return ride. That's what,
I can't, it's so hard to listen to yourself, so.
oh, I hear you. I hate to go
I
back
hate
and pull anything from these videos later.
Okay, so we're ready for the legal report. Is everybody okay with me just kind of summarizing as best I can, and then we can go through it all, ask any questions you have?
Yes.
Whatever you need, but we'll try it. So number one is 2025001121, and a summary of the allegations are that complainant is a licensed land surveyor in Tennessee, and that complainant alleges that respondent improperly submitted a subdivision plat that the complainant had originally prepared when they were working for this employer, a firm, an engineering firm. And the improper part of that allegation is that respondent left the complainant's certification as to the accuracy, the notes regarding the survey methods, the date, et cetera, along with the complainant's name. They left all of that on this plat. So that's kind of the first allegation. And then separately, respondent was acting as the responsible charge land surveyor for that employer, that firm, while operating their own land surveying firm or company. And in addition, they were not a principal or officer of the engineering firm as required by law. I believe, and I argue that this is made worse. It's an aggravating factor that the complainant went to the respondent and that previous employer prior to filing this complaint. Tried to talk through it with them, tried to say, look, I don't think we're doing this right. I don't think my certification should be on this plat. And additionally, you seem to be offering land surveying services without a proper responsible charge. And they basically disagree. Respondent didn't take action until the complaint was filed, and the engineering firm didn't take action until the complaint was filed. Now, I will get into the engineering firm's complaint with number two. So let's just talk about the actual respondent who is a licensed land surveyor and those issues now. So my recommendation for just against respondent here, the licensed land surveyor, is, sorry, I'll make sure that okay. The fact that respondent and their previous employer were both made aware of these issues prior to the complaint, their failure to do anything about the issues until this complaint was filed, I argue that makes it an aggravating factor. So I am recommending the maximum fine for each violation. And I recommend a $3,000 civil penalty for misconduct and or gross negligence by the respondent, improper use of respondent seal or stamp on the survey with complainant certification, and then failure to properly perform the land surveying services related to this plat on his own once he took over, and then also acting as the responsible charge of service for more than one business.
Well, I'll start off and say that the question, and I may have misunderstood this in there, but do I read this right, is that at one point the complainant's stamp and the respondent's, or that there was two stamps on the survey at one time, or I see where the
Yes.
respondent's signatures and notes and certification was on it. I wasn't, and I thought I understood that his signature was on it once as well.
Yes.
Or is that the complainant who was?
So hold on, let me find that part. I'll read it to you verbatim. So the plat replaced complainant seal with respondent seal. Respondent added their company logo on the plat and the engineering firm logo on the plat while leaving the certification block with complainant's name and all of complainant's original notes on the survey.
Okay.
But it's, from what I can tell, without doing like a full investigation, it seems that respondent may not have done all of the work necessary when he took over that they're supposed to do when they add their seal to something that was started by somebody else.
Right.
But I could be wrong about that.
Well, and I agree. I don't know that I see that in the investigation either. But the fact, I do agree about the time delay is a little troubling because this is going before a city review committee of some kind.
Yeah,
for a plat,
a city planning commission.
And there's nothing fast about that. So, I mean, that is at the very least usually a 30-day process and more usually of that. So there's plenty of time for things to figure out. So, but by, not realizing that they had left on the surveyor who had left the company's signature and name and the notes and all, doesn't show a very high level of being aware of what's going on with the product.
Right. And the respondent admitted that, yep, the complainant told me it was there. I disagreed. I thought because it was the firm's property that we could basically do whatever we wanted with it. And again, had a chance to fix it, didn't do anything until the complaint was filed.
Yeah, and I'd have to separate on that. I mean, there's one thing if you had completed drawings that you had signed and left into the company's hands when you left the company, that I think they do have the right to send them out as copies, but it has to be verbatim. Once you start changing them, then it's all of a sudden it becomes that company's and whoever the replacing surveyor is.
And that's what the complainant, had an issue with.
Yeah.
Like, I started it, I did this work, the city submitted review comments,
And they changed it, and it
and then
should
the
have moved
respondent took over, made changes,
Right.
addressed those comments.
Yeah,
But
that's-
left
I
out
believe
all of
that's
the
absolutely
complaints.
correct.
But they removed the complainant seal. So it looks like maybe in the accuracy statement, the certification block, they left his name typed
Yes.
under there. But there's no signature of the original surveyor left on there. They didn't forge a signature, so to speak.
No.
It
There was no
It was
forging.
just something that was left. and
Yeah.
not- Okay.
And I think the argument is that, and this is a little bit confusing to me, so correct me if I'm misunderstanding, or the complainant is, but I think the complainant's problem is that the respondent should have gone back and done all of that work if they're going to leave the certification on there and the notes on there. They should have checked everything. But I might be misunderstanding the level of duty you have there.
No, they should have checked all that stuff for
Yeah.
sure.
Yeah,
I mean,
and it's definitely a big miss that they left that name on there.
It should have
I
just
mean,
been taken off.
The certification block is almost standard. I mean, lots of surveyors make the exact same because we outline so much of it in the rules that it needs to include these things that it's almost become a standard language. So that doesn't bother me as much that didn't change other than they left the name. That's egregious to leave somebody else's name on there.
Right, and it's would be, I mean, in companies that only have the one surveyor, the CAD standards will get into the habit of automatically putting that surveyor's name on it, but, I don't think that's a good idea because this kind of thing happens on that, but particularly if you're in a company with multiple surveyors, you want to allow whoever's actually running that job to put his name in, so.
I had a question. What's the is there a protocol for the first surveyor to footnote his work relevant and the next one? Is there a protocol such that I could look at a document and say, well,
There is a document, we do have in the rules that if a surveyor leaves or dies, because they go in both ones, is that the surveyor who picks up the one has to go back and do enough work where he is familiar enough with the project where he can take, for one, he is going to take responsibility for everything. There is requirement for him to do sufficient review of the materials where he is truly in responsible charge.
so we would presume that this second, the second guy who's picked up this stuff had reviewed thoroughly he was pretty well versed with the documents if he put his stamp on it.
That would be the assumption. I don't think the investigation addressed that one way or the other.
I got
I think so. We didn't do any kind of we didn't send an investigator out because I had so much information and a lot of admissions. If the board wanted that, of course we could still do that. But what the respondent said in regarding that question is that they had recently field verified some corners, checked some deeds, confirmed the boundary survey produced by the complainant appeared correct. That is the only information that they said that they did. And I thought if they did more, they would say they did more.
Right.
You kind of wonder if, that seems like the bare minimum, but again,
and
I
is that
could be wrong.
sufficient? So that you kind of that, and I did read that, and I wonder if that's sufficient.
I think that's the question that I still have.
Kind of comes down right.
Well, and that's where, without additional investigation, I don't know if we really answered that on that. It may just be a bare bones statement of where, yes, he was going through what he was supposed to. But anyway.
If I can jump in here
You
real
can
quick.
jump in, Jay.
Okay, so there's, in situations where a second surveyor takes over a project, there's basically two ways you can handle this. Number one, I think we discussed here briefly already. But the second way is if it's more of a revision to a survey, you can have two stamps as long as it details what each stamp is responsible for. That's not what happened here, but just outline that is an option.
That is my understanding as well.
Yeah,
Thank you for
it's in the rules.
I was curious about.
Yes,
Okay.
you can put two stamps, but you are supposed to detail
Yes.
who had what
Right.
responsibility.
Okay, so back to this case right here. The part that gives me heartburn is in 08-2004.08, Section 9, which addresses exactly the case here. And I'm just going to read it verbatim, just bear with me. In circumstances where a registrant in responsible charge of the work is unavailable to complete the work, a successor registrant may take responsible charge by performing all the professional services to include developing maps, plats, surveys, or other documents. Okay, so here's the part that gets me. The burden is on the successor registrant to show such compliance. The successor registrant shall have control of and responsibility for the work product and the signed and sealed originals of all documents. There's where I see the violation. It strictly puts, and rightly so, puts the burden on the successor, the new surveyor.
Makes perfect sense.
He claims that he went out and did the field work and deeds and all that. I'm not disputing that a bit. But when it came down to the final plat, where it still contained the original registrant's name on there, not stamp, not signature, but name, that's where I think the failure hits right here. And that's where I see the violation. Is that where legal sees this particular aspect of it?
And that what you just went over is I cited that rule and kind of summarized that
You
in
did.
the first paragraph on the second page.
Okay, so that's where I see this violation right here, is where, is there any other discussion on that part? Does anybody see that in another way?
No, that's exactly it. It may seem like the fact that they overlooked a few things on the drawing, but that's
That's part of
when you're in
responsible charge.
responsible charge, that's it. And whether it's a big mistake or a small mistake, it's a violation of that rule.
Okay.
And the responsible charge is a serious thing.
So the other discussion, I believe we put that one
Yep,
to bed there. The other discussion was about the responsible charge.
right.
And was the violation here that they didn't file the necessary paperwork?
So
Is that correct? Or
they were
didn't have
not a
principal?
principal or officer as required, and they were acting as their responsible charge for their own land surveying company, which you can't do that either. You can't be the responsible charge for two companies at different addresses.
I was thinking, that's like, you can't, brokers are the same way, right? Real estate brokers, I don't think you can't be the broker for two different firms.
I think so. And,
But, yeah.
part of that might also be, you're supposed to be working 30 hours a week at a minimum as the
yeah.
responsible charge. That's pretty hard to do.
It's a full week, right?
Yeah, I think that is part of, why you can't be doing that for two companies. But we have a lot of that in this report, you'll see, just the responsible charge issue.
Can I ask a question?
Sure.
And this goes to, the question goes to, how do you define an officer or principal of a firm? Is that something that has to be on letterhead? Is that something that has to be documented somewhere? Is that just something that just says, hey, Gary, you're now principal of my firm? How does that work? Or is that the purpose of the registration form that, as surveyors, we have to submit saying, look, I'm the principal in charge of this firm? Is that how we cover our base here to
Yes.
define principal and officer?
It's on the practice disclosure that you're supposed to file. It's not defined anywhere, so I would say that you use like a Webster's definition of principal or officer. But you are stating when you file that disclosure that I am a principal or officer.
Was that filed in this case?
No.
Okay.
And I do want to just throw this out there before we make a decision on this, because the next complaint is against the company itself. So I just want to make sure that the board, if we decide that this is a violation, that we are okay with, or at least considering whether we want to hold the respondent here accountable for that and the company.
That's my next question. Where is the burden placed? Is it on the surveyor who is in responsible charge? Is the burden placed on them to file that? Or
They
is it
do
on the
file
company?
it.
It is on the surveyor themselves?
Yes.
Thank you. I'm good. One more question. One of the, on your recommendation, I think it was under the TCA, 6218 on 116, dealt with misconduct and negligence. I've got a little heartburn there.
Okay.
I'd like to hear your rationale behind where that falls in here.
So it's pretty vague and left to the discretion of the board how you want to interpret that. If you can decide that something is that a licensed land surveyor has been negligent or engaged in gross misconduct, kind of how you want. That's how the statute reads and the rule reads. But my argument is that this respondent was made aware of the problem and chose to not fix it. And to me, that's kind of intentional. That's gross misconduct. At the least, it's negligent. So that's where I got that from. That they chose to leave that certification and not fix it.
So under 08200407, which is titled misconduct, item 1, the first one, the registrant shall not partner, practice, or offer to practice any person or firm that the registrant knows or has reason to believe is engaging in a business or professional practice of a fraudulent or dishonest nature. Is that the rationale that you're...
Can you tell me where you're at?
I'm sorry, 0820, it's under the rules, 082004.07.
Okay.
Entitled misconduct. Now, I think in your recommendation, you referred to the TCA, I believe.
Yeah, it's in both places. But I'll address the rule first. So .07 defines kind of, or talks about misconduct. Number 1,
I don't know that it applies there. That really deals with it seems to be dealing
okay,
with
this
the
is where
business practices.
Where I got the discretion from is 0703, or paragraph 3.
Right.
The following acts, among others, may be deemed to be misconduct. So to me, among others, leaves whatever you want to be misconduct or negligent, because we don't list all of the possibilities of what a land surveyor can do. They can get creative in being negligent or engaging. We don't say specifically you can't do what happened here, but in my opinion, that's not allowed. So I kind of was using that vagueness And then to go back to the statute, 116A1B. Basically states that the board can take any kind of disciplinary action against someone who's engaged or is incompetent, has engaged in misconduct or gross negligence in the practice of land surveying. And again, to me, that's very vague. You can match it with the rule, which I found was also vague by saying, here's an example of misconduct or anything else. I think part of my reasoning for using that too is, like I said, there's nowhere that says you can't leave somebody's certification on there, but I still found it to be improper. And when they're made aware of it, I found it to be misconduct. So I just thought that would be the best way for us to kind of where we would put this violation in the rules and statutes, since there's no like rule or statute that specifically says you can't do that, other than, I guess, the .09 that we were talking about, .089.
Right.
And I'm open to, if you're not comfortable with that, again, this is at your discretion. We don't have to, we can say that's not, he didn't violate that.
I think you answered my question there. As much as I admire the amount of research that you put into this, I can tell there's a lot going on there. You also stated, and I tend to agree with it, it's very difficult to define misconduct and negligence. It is difficult, even though I'm agreeing with everything you just said. I mean, I'm like, right there. I don't know if this were to go further, that burden of proof is there.
Okay.
I just don't. I'm not saying I disagree with you. I just don't think it's there, in my opinion. I do feel the other violations that we mentioned, especially the 08 Section 9, and then also the failure to file the proper paperwork. I do see those two violations, and am prepared to make a motion on that. But certainly I want to hear the rest from them. So that's where I'm at.
Justin?
When did, I'm sure it's in here, but when did the complainant reach out to the respondent and notify them that they've seen some issues?
I don't think they told me. I know it had to have been before December.
Okay.
This complaint was filed on January 7th. But I can, let me see if I can find that.
I'm just saying, if that's an aggravating factor, that they had time to resolve this.
And they admitted to that too. It's not like, that's not in dispute. They said,
Oh,
yes,
okay.
we had this conversation, we disagreed.
I got you.
But eventually, we agreed. They disagreed with the certification, but then once the complaint was filed, I guess they talked more about it, and the respondent agreed I should have done this differently.
Gotcha. Okay. Well, that's good enough then.
I wondered about that because it seems like it seems like after they brought it up and they didn't change, they didn't correct it. To me, it's such an egregious error that it almost wasn't like they didn't believe they needed to correct it. I wonder if, like, I think they actually were thinking, no, this is the right way to do this.
Yeah, I mean, I believe that at first that's what they thought.
Right.
The respondent eventually, I just want to tell you kind of what they, let's see.
Yeah.
Respondent agreed it was not right to submit the plat and apologized and acknowledged some, quote, copy paste errors. That was kind of their, after the complaint was filed, their admission.
Yeah.
They said they were given the CAD file by the,
Yep.
their employer, and thought it was their right to do basically what they wanted to do with it, if they had checked things. That part, again, is like vague, what they said that they did and didn't do. They didn't really go into great detail there.
Sounds like just kind of get us caught up. What I'm hearing so far, we're disputing misconduct. Obviously, there's some objectivity there, but some subjectivity as well, discretion. So we're not so sure about that one. But we do see 2 violations based on what we have, and then we have a recommendation in front of us.
And I've got one more thing. I don't know if this will be helpful, but the respondent, in the end, this is their words, that they acknowledged their, quote, quality control process should have been more thorough before resubmitting the plat. They should have removed the notes and certification information bearing the complainant's name, and more definitive modifications should have been made to ensure the final plat clearly reflected respondent's work and professional responsibility. So that seems like a pretty big deal, in my opinion, to admit to that.
Yeah, and I think we're all on the same page that that's where
Yeah.
it really went off the rails.
I'm prepared to make a motion if there's no further discussion. All right, hearing none, I'll make a motion, subject to violations to Rule 0820-0408, Section 9, burden of proof, and also 0820-04.10, Section 2, firm disclosure form. I'd suggest a civil penalty for each violation of $1,000 for a total of $2,000.
I'll second that.
All right, we have a motion from Jay Kaufman in that regard for those 2 notations by rule, and then a second from Justin Raines as well. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none then, that was approved. I think we're ready for number 2.
Okay, number 2 is 2025-001131, and this is the same complainant. The respondent is the actual employer, the civil engineering and site development design firm. The allegations here are very similar, that the firm allowed a surveyor to use the complainant's plat and certification. They were also given plenty of notice and decided that they were doing the right thing until the complaint was filed. And then also just allowing the land surveyor, the successor land surveyor, to act as the responsible charge, knowing that they were acting as their own responsible charge for a separate company. They were made aware of that too before this complaint was filed, and didn't do anything until, they say, the day before the complaint was filed, but that doesn't really make any sense to me. And then in addition to that, while they were didn't have a proper responsible charge, they were advertising land surveying services on their website, and this bothered me. I don't know if it bothers the board as much as it bothers me, but they stated on their website that they are a firm that has a, quote, in-house team of surveyors that serve the local area on a regular basis. That never seemed to be true. So I don't know how big of a deal that is, but it seems pretty misleading. And once this complaint was filed, they removed that. They removed the offering of land surveyors completely from their website. But this may have just been a mistake, but they are, like, if you know, a lot of companies have like an about tab. It's still there in the about tab. So that could have just been an oversight, but I wanted to bring it to your attention. So my recommendation is a $2,000 civil penalty against respondent for violations of the same misconduct, negligence. So I guess we could probably throw that out here because we threw it out in the first one. So I'll take that recommendation off the table. So that would just leave a $1,000 civil penalty for offering land surveying services without a proper responsible charge. I know we talked about the possibility that we're kind of doubling down on the firm and the land surveyor, but I argued that the land surveyor has the responsibility to file that disclosure, but the firm has the responsibility to not offer land surveying services without a proper responsible charge. So that is, to me, they're different. It's up to the board if you disagree, But that's the only violation we have here. So if you disagree, I don't think it would be proper to issue any civil penalty.
So I'm on the same thought train as you are right there. I want to expand a little bit on the advertising services, and I need a little help from the board and y'all as well. Where is that section in the rules here as far as cannot offer the services without having that on there? I just tried to breeze through while I was here. I just can't put my thumb on it. I know it's in there. I just can't put my thumb on it. But I'll expand on while you're looking that up. I will expand. Yeah, the only violation that I see in terms of the company itself goes to 08-20-0409, responsible charge of service. Because the burden of filing the disclosure form falls on the surveyor, I don't think that applies here to the company itself. And I think we've addressed that in the previous issue. But rather, I do think the company is responsible for the only officers and principals who are employed full-time for a minimum of 30 hours. Can be the responsible charge of service. I think that's where I see the violation. I think you were agreeing with that the violation that we have right now that I see is 08-20-0409, the responsible charge. Did you find the offering
Yes.
services? Where was that?
So right after 09 in .10, it reads, a corporation, partnership, or firm offering service to the public may engage in the practice of surveying in the state, provided at least one of the principals or officers of the business is in responsible charge and is registered as required in this chapter.
Thank you. Yep.
And then even further, firms offering surveying services to the public shall file the same disclosure, but they don't have to file it separately. But in my opinion, that first part applies.
I have to believe that the firm, because of the surveyor, they didn't. I believe that they thought they could. I believe they thought they could.
Yes,
offer the
I agree.
services. So,
I agree.
So although I think there's a lot of teeth there in that point 10 that you found for me, thank you. I don't know that it applies directly right here. I don't. So as far as the way I see it, the only violation I see towards the firm itself would be the 08-20-0409, the responsible charge. I'm open for other thoughts.
I'm going to explain that one to me. I may have, so it's the fact that the one surveyor that they had, they did not disclose or have put together as being an officer as well, or a principal on that, which is the responsibility of the surveyor if he is going to be the one for that company.
Well, I think the burden falls on the firm to appoint the registrant as an officer or principal, and that was apparently not done here, nor was it disclosed on the disclosure form.
Okay.
Is there any issue with the timeline as it relates to that? Because all this was pretty much encapsulated in 2 months, right?
Right. Well, the practice disclosure, a firm is given 60 days to update that. But the problem is I can't find a single one. So it was just never filed in the first place. But if you're filing them properly, you do have 60 days to update the change.
Does that mean that the complainant in the first complaint was in violation of that?
I have not looked to see if he filed one.
Okay. I thought you meant the firm had never had one.
Just for this respondent.
Oh, okay. I
Yeah.
get you.
So, but I see your point.
Yeah, my only thought there is if you have a 60-day grace period, I mean, it looks like it did go a few days over that by the time they got rid of him, but before that 60 days was up, they had scrubbed their website. I mean, it seemed like some good faith effort to
Right.
back off of it.
I totally
I don't know.
agree. It seemed like they waited until this complaint was filed when
Yeah,
they
I
had.
get it.
That bothers me.
I get it. It's a little tough because.
But it might be a common misunderstanding because, I mean, we've got 3 complaints here about the same kind of thing with different companies. So maybe it's a misunderstanding among the industry.
Well, I think it's definitely a misunderstanding amongst the industry because it's come up even with discussion to me from time to time that they don't quite understand. And of course, that's one of the rules we're looking at clarifying since there is a misunderstanding, but because I'll dispute the interpretation that you have to be an officer in the company or an owner to be able to sign it, because many companies have multiple land surveyors. And if you got a license, you get to sign. But there's no dispute that it's up to the company to designate an officer who has a license into the closure or some method that they're an owner, and I don't dispute that.
Well, it says an officer or principal.
Yes.
Or principal,
And I've got a little question there. I mean, if you're the only licensed surveyor on staff, are you not de facto the principal surveyor?
But again,
don't know.
I think the company has to me, I think I understand what Jay was saying, that the company has a responsibility of making sure that that's clear, because they have some culpability for that as well. But the surveyor himself needs to be aware that he needs to educate the rest of the company of what needs to be done.
Sure.
That, because it's unreasonable to expect them to understand the surveying rules as well as everything else. But then ultimately, I think they both share some responsibility here of not taking care of that. You know, I'm not sure of this idea that you can't be signing plats from two different companies. That needs some clarification, but it's not really applicable right here, I think, to it. It's more about that they were advertising that they had in-house surveying, and they didn't really have any in-house surveying for a time.
It is laid out in 09 about that you can't do it for two. It says an officer or principal may be in responsible charge of more than one firm only if the firms are at the same physical location.
Right, but doesn't say that you can't be in responsible charge of the survey. Which is
As long as you have another like responsible charge that's properly.
Right.
Right. No, I agree with that.
Yeah. But, so I think we're in agreement here of what the problems are. It's the biggest one is they're advertising that they have surveying, and they had a gap there. They didn't have anybody in reality.
But they thought they did, you know. And I'll just add, and I'm sure you know this, I think a lot of this misunderstanding and confusion might come from the fact that they used to have to have a firm license. Is that correct? A surveying firm license, or was that never a thing?
That's never a thing in Tennessee.
Okay.
A lot of other states.
A lot of
Okay.
other states do require the firm
Okay.
to be licensed as well. And I've had to educate my own company of that responsibility too. Again, they just didn't know, you know, that's up to the surveyor the individual surveyor to be sure that the company is operating within the rules of it.
Understood.
Would you like to put that in the motion, Jay? I like your motion.
Well, let me know if my motion covers. I'll attempt it. I'll make a motion to show a violation of Rule 0820-0409, responsible charge of service with a civil penalty of $1,000.
All right, we have a motion in that regard. Do we have a second?
Second.
Got a second from Mr. Raines. All in favor, please say aye.
Aye.
All right. Any opposed? All right, hearing none then, that was passed. Thank you. Number three.
Number three, a little more simple, 2025-003601. Complainant alleges respondent moved some survey markers and was inconsistent with some past surveys. The complainant respondent resolved this after the complaint was filed. There were some misunderstandings, and there's no evidence of any violations, so my recommendation is dismissal.
Make a motion to accept council's recommendation and dismiss.
I second.
We got a motion. Somebody. We only can do four at a time. You know, that's the only bandwidth we paid for. So, all right, we got a motion from Mr. Raines to accept council's recommendation. Got a second from Mr. Martin. All in favor, please say aye.
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 Any opposed? All right, hearing none, then that one was passed. Number four.
Okay, number four, 2025-005-291. Complainant is a licensed land surveyor. They allege respondent has been operating their surveying business without a proper responsible charge. Basically, the respondent here doesn't have a license, but has been working for this firm, this land surveying firm, for 13 years. Their cousin operated it. They were licensed. The cousin died in 2020. Since then, the allegations are there's never been a proper responsible charge. Complainant was going to merge their business with respondents. They had an NDA signed. Eventually, the complainant dropped out of wanting to merge their business. They didn't feel like the respondent had made enough effort to get licensed. I guess they've taken the exam 4 times, allegedly, and haven't passed it. And they also, the complainant believed that during this time since 2020, they've been offering land surveying services without a license and without anybody reviewing some of this work. So there's never been a practice disclosure filed that I could find since the cousin died. So that's since 2020. So that issue seems to be pretty clear. The complainant's also concerned about their own mistake of maybe because they have their own land surveying business. Now, there was a contract in place to possibly merge these 2 companies, but they just wanted to, make that clear that if they're in violation, they've done anything wrong, here's their self-report, this complaint. But more importantly, I think they're just concerned that this business has been operating for 5 years without a proper responsible charge. There was another land surveyor, licensed land surveyor, that was also reviewing some of this work for a few years. Their eyesight's kind of gone and is not well enough, not good enough to continuing doing the work with respondent here. That's when the complainant came in, and they were going to merge their business. That didn't work out. So really, the allegations are really similar to what we've been talking about. My recommendation was to authorize a $1,000 civil penalty for the same violations in the last case, 0.09 and 0.10, for failing to have a proper responsible charge and not filing disclosure.
Well, I think this one's a little different in that, I think this is the one I understand, that they were, the loss of the ability of the surveyor in charge was kind of a sudden thing. They had something planned to correct it quickly, which would have been good, and they could probably even got some leniency, but they went on for 5 years trying to fix it. That's probably beyond that.
Yeah, and that licensed land surveyor was also, it was just never proper. They weren't an officer or principal. They were a mayor during this time, and they had filed a disclosure with their own engineering company. So there's like multiple reasons why they should have never been the responsible charge. But again, I go back to this company thought they had a responsible charge. So it's up to the board to decide how bad that is.
I think this one's fairly cut and dried and egregious, that they went on for an awful long time without having a surveyor and responsible charge at all.
Right.
I mean, without even getting involved into whether they were an officer or principal.
Right.
They just didn't have anybody reviewing who was licensed reviewing it. They had someone who was going to get licensed reviewing it.
Well, they did have 2 licensed land surveyors reviewing it. It was complainant at one time when they were going to merge their companies, and then this other licensed land surveyor who was the mayor, the responsible charge for his own engineering firm. So from what I can tell, they always had somebody licensed reviewing their work. It just was never according to the rules.
Right.
And it did say that the first surveyor that was reviewing their work, there's a statement in here, worked at least 30 hours a week for respondent and did not act as a land surveyor for any other business.
That's what he said, and then I found out that was not true. And I've asked them to address that, and I have not gotten a response.
Gotcha, okay.
Have we seen this before?
Not that I know of.
This has been in front of us before. I've heard this story before.
I don't remember it at all.
At a previous meeting of some sort.
This sounds really familiar.
Self-contracting, you know what I mean? In all the industries, you just,
I mean, I've heard similar ones, but I've never recognized this name or
Okay, all right.
the situations. Yeah, like I said, it must be a common problem because, yes, you're right. This situation has come up multiple times, but I don't remember the mayor
Yeah.
problem.
Okay, so I think there's 3 parties here that are in actual violation. In
That
the
is-
third one being the mayor, so to
Yes,
speak.
and I'm waiting to hear back from the attorney on that issue.
So the violation I see in terms of that surveyor, i.e. the mayor, is failure to file the disclosure form. I see that
Right.
So I
They had
think-
filed one for another company.
for another company.
In
Yeah.
2019, so
But not
I've.
for this one.
He may have stopped. That's what I'm waiting for an answer
Gotcha.
on.
Okay, all right. So there's a little caveat there. Okay.
But they never told me. It bothered me that I had to find that out myself.
The complainant also seems to be in violation as well, and he does somewhat self-confess that
Absolutely.
here.
He's like, I welcome whatever the board thinks is appropriate here. I'm.
And I see that your recommendation is a letter of warning to the complainant. I would tend to go a little stronger on that.
Okay.
I do give him the credit for bringing this to us and all that. I give him all that. But in terms of being consistent,
Yeah.
and similar to the prior cases that we've already reviewed, I would suggest a $1,000 civil penalty on that, above and beyond the
I
letter
kind
of
of,
warning.
I think there is to assess the same civil penalty for somebody who self-reported to somebody who didn't. I mean, do we
I
want to
agree.
lower it a little bit?
I agree. And I see where you're going there, but
Maybe
but I
500?
still believe in consistency is a path to follow here. And again, I give him all the kudos for bringing this
Okay.
forward. I really do. It's just my suggestion. They may see it different. I'm good with that. As far as the respondent goes here, a 1,000 penalty, I would suggest a 1,000 on each for a violation of 04.09 and 10 as well.
Okay.
I think they're both viable here. Again, consistent with prior cases. I would suggest a 2,000 in total civil penalty there against the respondent there. So I'm not sure how we want to handle the mayor. I guess we're still kind of pending on that, some
Yeah, I
information,
mean,
and we may want to table that. I guess we could.
I can go ahead and open a complaint automatically without waiting, or I can wait for the answer. And if I see that there's no violation based on the proof they give me, I won't open a complaint, or we can just open one. Anyways, it's up to you.
I would like to chase that.
Okay.
I don't know what the procedure is. If board needs to open a complaint on that to follow up on that.
Yep.
Again, if they can show that, hey, we're
Then I'll
we're good,
recommend,
then
dismissal when I bring
we'll
it
dismiss
before
it.
you.
But I
Okay.
would like to chase that one. So
Okay. So
Okay.
open a complaint against.
that's my suggestion.
Yeah, and in relation to that, I would love to know more about, it says they had contacted the Board of Examiners and asked for leniency.
I have asked who they spoke with, and I'm still waiting for an answer on that.
Okay.
They spoke with Phil, and he just shut that down. That was it.
This had to have been back in 2020. That's when they
Well,
supposedly had a conversation. So that's,
That may be why
I've
Justin and I are
asked,
very
it's
curious
been like
about that,
weeks
it
since
was
I've asked. So
before.
that bothers me because they've gotten back to me but not answered that question.
Well, yeah, I was just curious, like Justin, when they said that they talked to the board, I mean, that's, of course, we correct people all the time when they stop us on the street that they're not talking to the board when they're just talking to me. But was there any evidence that this actually came before the board in 2020?
No. What they state is that there was a phone call, and I assume when they say the board, there was one person from the board, possibly. I don't even know if that's a staff or a board member. I don't know because it was before I was doing this.
That doesn't matter. In either case, is it the board? It's just.
Right. And there was a state representative on the phone supposedly as well.
Can I ask what county this occurred in?
Probably not right now.
Yeah.
Okay.
At this point, no.
Well, but the fact that they asked for leniency says they knew they shouldn't be doing it, and it went on for over 4 years. I mean, that's, to me, that.
Correct. And it
Kind of-
it bothers me that I wasn't told that this person had filed a disclosure with their own company. That I had to like do detective work to find that out. And then once I brought it to their attention, I have not gotten any kind of response.
And I do agree that there is a lot of confusion about disclosing who's the primary or principal surveyor in a company. That a lot of companies aren't even aware that's a thing in Tennessee, whereas other states require that you actually do a formal registration of the company. So that is in there, but again, to Jay's point, it's important to be consistent. That's the rule, and you are supposed to know what the rules are, one way or the
Yeah, and
other.
I mean, obviously, I know, if consistently, it's hard to measure that. We don't have a metric in front of us. We don't have, I can't bring the other cases before you. I'm sure recollection, would be accurate. But then the difference between those that self-reported and didn't self-report, we don't have that in front of us. So, it's.
I will say where I get that from is in our rules, we can consider mitigating factors and aggravating factors. So I thought a self-report is a mitigating factor, but so you have the ability to consider that and still be consistent because that's what makes it different than these other cases. But if you don't feel like it's enough of a difference to warrant a different fine, then
I think normally I would
you know.
agree with you, but to me, there's one that's going the other way as well, in that this didn't become a complaint until they couldn't agree on a price to buy the firm, and now, obviously, they operate in the same area,
Very true.
There's some benefit that could be gained by stopping what they're doing. So, I think that might kind of wash the mitigating factor there a little.
Are we
You
on the
want to jump
cusp
in
of a
there,
mo-
Kevin, anywhere?
My thought was I could hold a piece of wood and say I'm speaking to the board, so that's comic relief. But no, I don't really have any thoughts on it.
Jay, did you put a motion out on this one, or?
People, no,
Okay. Would you like to?
I would like to. I would,
If you can go ahead and use, yeah. Yeah.
thank you. Along with the recommendation from staff, I'd like to modify that just a bit to authorize a $1,000 civil penalty against the respondent for a violation of Rule 08-200409, and additionally, a $1,000 civil penalty against the respondent for violation of Rule 08-2004.10, for a total civil penalty of $2,000.
Excuse me. We got a motion from Jay Kaufman in that regard. Do we have a second?
I second.
Got a second from Mr. Martin. All in favor, please say aye.
All right.
Aye.
Any opposed? All right, hearing none, that was passed. Thank you. Number 5. Oh, okay, carry on. All right, carry on.
So, back to discussion, if I may.
Sure, of course.
So that was against the respondent itself. So separately, I want to address within the same complaint here, how we want to handle the complainant here. I suggested a $1,000 civil penalty, again, taking into account leniency of any kind for self-reporting. But I did kind of want to get a consensus from y'all where you wanted to go with that before the motion was made.
Well, I would agree with that because I see a lot of back and forth right here, and I think, again, with consistency, we need to be telling both of these folks that they should have straightened this out amongst themselves earlier. They had all the opportunity in the world to do it, and if one gets a civil penalty, I think the other hits an equal.
Yeah, I agree. I'm on board.
Okay, so I'll make a second motion here, directed toward the complainant for improperly acting in responsible charge in violation of 08-2004.09 with a civil penalty of $1,000.
Second.
We got a motion from Jay Kaufman in that regard, a second from Mr. Raines. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none, that was approved. Do we have any other motions for this particular case?
Did want to clarify that we were going to chase the mayor, so to speak.
Yeah, just instructions in that regard is fine. We can just open up an administrative complaint and then present that to the board. Yep.
Very good. I'm good.
All right. All right. Well, I believe we're ready for number 5 then. All right.
Okay, number 5, 2025005411. Complainant alleges the respondent may be attempting to circumvent subdivision rules and bypass county planning commission review by listing plots to be over 5 acres to meet the threshold when the plots may actually be under 5 acres. So I had this reviewed by an expert. They found no proof to support the allegations, found actually that the acreage was correct based on all of their review of all the documentation submitted by the respondent. However, they did find some technical issues during the review. One, the graphic scale was missing. Two, the category 1 through 4 wasn't cited on the certificate. And then last, the published fixed control should cite the base stations used in the Opus report. So my recommendation was to issue a letter of instruction regarding those technical violations. Again, I don't know how bad those are. If the board believes those are more serious for a letter of warning or even a civil penalty, I'm open to hearing that discussion.
Well, I'm not too happy about them not putting the proper certification on it. The graphic scale would be a simple CAD mistake, but the certification, no, that's, to me, that's worth a letter of instruction back to them for sure. I mean, you can include the graphic scale because that is in there, but that's my opinion anyway. I didn't make a motion. I'll let the rest of you talk.
I don't know that it shouldn't be a letter of warning. I mean, that's a pretty clear violation. I mean, we reject applications over that very thing. I mean, that's a significant, I mean, I agree the scale, okay. But that certification is the binding thing on there that, you know, where you're stating what you're certifying to. If you're not doing that right, it's a problem. So I think elevate that to a letter of warning.
Okay, just clarify. So the letter of warning actually is a disciplinary action or none of them are disciplinary actions?
No, the letters are not reported to, on like our disciplinary action report or reported to any other state. It's just a letter of warning is just more, we find evidence that there is a violation and remember, here's the law. This is your warning to not do it again. Whereas a letter of instruction is more, there seems like there may have been a problem and if there is, here's the rule that applies.
Okay, so a letter of instruction would be more for things that aren't necessarily covered in rules, but would be ethically or just common sense bad practice.
Right, or that we don't have clear evidence of proof, but it seems like it might be a problem.
Or clear jurisdiction,
Yeah.
but, so, yes, the warning, I would agree then. I just get confused which one's the harder one.
Right, I understand.
So do we have a motion in that regard for a letter of warning from the board?
I'll make that motion for a letter of warning.
Second.
All right, got a motion from Mr. Kaufman for a letter of warning, a second from Mr. Raines. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none then, I think we're ready for number 6.
Okay,
One of these days, we're going to have to change the definition of these letters to
Yeah.
warning 1, warning 2, so I know which one's which.
Well, they're different in some other programs too. I had to sit there and think about it too, because I was like, in Praiser, that actually does go on the registry, doesn't here, and so it's, it's a whole thing, so, yeah.
Okay, number 6, 2025-003-731. Complainant alleges respondent was involved in cutting their fence to make an easy path to an adjacent property for survey work. There was no proof to support the allegations, and a neighbor actually admitted that they had made a mistake, thinking that another person on the property was respondent when it wasn't. So there was just misinformation passed. So based on the lack of evidence that this is true, the recommendation is dismissal.
Yeah. Move we dismiss.
All right, got a motion for Mr. Clark in that regard. Do we have a second?
A second.
Got a second from Mr. Martin. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none, that's passed then. We're ready for number 7.
Okay, number 7, 2025-007-851. This one is very complicated, very convoluted. I'm going to do my best to summarize it, but I welcome any questions or more discussion once I do that. Complainant is a licensed land surveyor. They have actually been in communication with respondent, which led to this complaint being filed. Respondent is a licensed engineer and a licensed land surveyor in Alabama. They are also a licensed engineer here, but they have let that license expire. So they have no active license here, never had a surveying license here. They did submit an application in 2021, but never followed through. They have recently been suspended. Their engineering license and their land surveying license has been suspended for 3 years in Alabama. They got a $5,000 fine. This was following a lower fine a few years ago, all for the same issues that I'm about to discuss. So they were doing the same thing in Alabama. They just had their engineering license in Ohio revoked for offering land surveying services without a license. They have not reported that to our board. So in my recommendation, I'm going to be recommending we refer this over to the Architects and Engineering Board, because he may try to get his license reactivated after all of this. I think that might be why he let it expire based on my conversation with him. So I just wanted to put that out there. But all of the allegations I'm going to go over led to those disciplines. So the allegations are that respondent is offering land surveying services in Tennessee through 3 separate websites that they have. Basically, even in the website name is land surveying, and then like the city. I can't go into any more detail, but if I was a consumer, it would sound like you're a land surveying company here in this location. They even have addresses and local phone numbers on this website. The respondent is offering to like lease these websites to licensed land surveyors in Tennessee. That's one reason why they reached out to the complainant. They're like, hey, you want to lease this website and you'll get leads. Respondents also just offering to give you leads for like fees to make a commission. They also have their own engineering business where they're offering land surveying services in Tennessee. So they have like 5 different websites. They also have a bunch of them in the state, like in Alabama, that are separate. It's just their argument is that they're a marketing business. They're just marketing websites that happen to be called land surveying companies. It's very, like I said, it's very convoluted. This person's obviously an expert at this business model and has just waited to get caught and has recently been caught in Alabama, and now we've got it before us. The difference is they had a license there. They don't have anything here as far as land surveying goes. So the respondent ignored this complaint for a long time until I finally was able to get in touch with them. And I've only talked to him on the phone. He promised to submit a written response to all of the questions I had, all of the things we discussed, and the very detailed complaint 2 weeks ago. I never got it, never heard from him since I talked to him on the phone. Really just blew everything off when I was talking to them. Like, oh, this is just a misunderstanding. I only have marketing services. I said, well, what do you get out of any of this? Well, I get paid, I get fees. And he really wouldn't go into any more detail, but promised me a response, that I never got. So really, those are the allegations. Because they don't have a license, we can't take anything away, we can't suspend anything. And because it's so convoluted, I only can prove certain violations at this point. So with the proof that I feel like I have, my recommendation is to issue a $2,000 civil penalty for failing to comply with Rule .09 and .10 because they're offering land surveying services and they've not ever filed a disclosure stating who their surveyor is. Now, they did file one with the engineering board stating that they had a surveyor. I talked to that surveyor and they said no. I might have done some work with them in the past, but I never worked 30 hours. I was never an employee for them. I've never even been paid for half the work I've done for this person. So they're like, and if you need to talk to me in the future about anything, let me know. But really just kind of help me understand that a lot of this just seems to be pretty fraudulent. So yeah, those are the only things I could prove, though, because they don't have a license. And I've not had any complaints that I don't have any surveys or anything to show that they actually did anything other than advertise, although I believe they did.
Well, it does sound like that they're advertising practice of land surveying. They could be a licensed Tennessee land surveyor and advertising websites all over the state, as long as they weren't, and even could have the city in the name, I think. But if you're going to list a physical address, then the way I understand it now, they have to have a surveyor at that. Whatever physical address they list, that's where the surveyor has to be. But there's no reason that they can't advertise and other things. So I agree that this is terribly fraudulent. My problem is I don't think a $2,000 penalty is going to faze this fella.
It's going to be hard to track this person down in general. They don't live here.
And her citation, she's got 2 citations with 1,000 each, and so it's what you can prove, and then, and then the citations relevant. So it's the max from each. And so it's
1,000 is the max we can do for each violation, unfortunately. But I do think the teeth here is going to be with the Architects and Engineering Board, because they have a license there. When I talked to him, I said, "Are you going to renew that?" "Well, I might. I don't know." I think the plan is to let all of this blow over and see what happens with it. Again, they've not disclosed their Ohio revocation, which they have to do. So I think they're just kind of in waiting to see what happens with all of that. But I think the Architecture and Engineering Board needs to know about all of this, and they may be able to take more action.
I mean, I think it would take a cease and desist order to actually make any real headway, but then, again, that's out of my ballpark there.
Is there? I'm sorry.
I was just going to ask, so were they licensed in Ohio at one point?
As an engineer.
Okay.
And that was revoked.
Gotcha.
Is there a way to prevent a future application from this person?
We can't prevent anybody from applying.
I didn't think so. Yeah.
But we can flag a name so that this complaint comes up, and it can be considered
In the
that
okay.
we
All right.
never got a response. If we issue a fine, if they don't pay it, that's still out there. I mean, you can take it to a formal hearing even if you wanted to.
And of course, if he applied for a license and got one, then he gets to come under our jurisdiction.
Exactly. And if this was still out there and open, they'd have to deal with this.
I think this clearly is a fraudulent advertising. I mean, I can, there's a lot of these models being advertised and solicited that we will provide you leads for a fee. And that sounds like what he's doing. I don't care for the way that he's named it. I think that's pushed things over the edge.
It seems like if he suggested that I'm just hooking you up with a surveyor, that seems like would that be legal?
Well, it's just like a recommendation there. I mean, if he went and got it right, I think yes, he could do it. But the idea that he's got multiple websites that say land surveyor for the city in a particular city, but then the biggest thing is they list a local address and phone number. I think that's absolute fraudulent there.
And I will say, just in case this changes anything, when I was speaking to the respondent, I asked about that. I said, "What are these addresses?" And they said, one's a P.O. box, and the other is the address for a licensed land surveyor that's leasing that website. But it doesn't say any of that. I asked for the name of that licensed land surveyor, wouldn't give it to me. Promised to put it in the response so I could look more into this. But I just don't have any of that. And then the local phone numbers supposedly go to whoever's leasing it, or if nobody's leasing it, go to him as a marketer.
What about site name for each site that he has open?
Each website would be its own violation.
Yes.
Yeah. And each day. You really want to get it.
Okay.
There's a motion?
Yeah.
All right.
Yeah, I'll drop back now.
I'm going to make a motion following staff's recommendation, authorize a $2,000 civil penalty against the respondent for violation of rules 08-200409 and 08-200410, and for offering land surveying services without a license for a total civil penalty of $2,000.
We have a motion in that regard. Do we have a second?
I second.
Got a second from Mr. Martin. All in favor, please say aye.
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 Any opposed? All right, hearing none, that is approved. All right, looks like we're ready for number 8.
Question
yeah.
on that one is a follow-up. Do we have a mechanism to monitor the situation and open our own complaint on him
Open our own complaint on what?
on multiple sites?
Well, this is the complaint that's open. So what I'm going to do now is send out a settlement offer in the form of a consent order with a $2,000 fine. If they ignore it or don't sign it or want to argue about it, it will go to a formal hearing.
Okay.
And he will have to come before you.
Very well.
And it will not be closed until one of those it either gets signed and paid or there's a formal hearing. And until then, it's open. Meaning if there's an application, that will come up.
Okay, very well.
And I think we all can agree this will also be forwarded over to the Engineers Architects Board as well.
Yes, yes.
Thank you.
I actually didn't put that in my recommendation, but in writing, but that is part of it. So I'll just verbally say, part of my recommendation is to refer this matter to the Architects and Engineering Board.
Do I need to amend the motion at all? Or?
We'll go ahead and just to harden it up, formalize it. Let's do that, yeah. So, Mr. Koff.
So to amend the motion,
Or in addition to, yeah.
In addition to my original motion, I'd take council's recommendation to forward this information to the Engineering Architectural Board for their actions.
Got a motion from Mr. Kaufman. Do we have a second?
I second.
Got a second from Mr. Martin. All in favor, please say aye.
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 Any opposed? All right, hearing none then, that is taken care of. We're ready for 8.
Okay, this is the last one, 2025-019771. Complainant is a licensed land surveyor and respondent is an unlicensed individual. Complainant and respondent used to work together, and complainant still, I guess respondent left that employment, but complainant is still getting some emails to the respondent's email address. So a purchase order for a job for a construction company came to complainant's email, and that is what led to this complaint. The purchase order referred to surveying services in the work description and showed that respondent would be providing services listed as, quote, stake property lines on a time and material basis at the following rates, $10,000. There were some other services noted on the purchase order that just made it look like this is their standard purchase order for surveying services. Those weren't filled out. Only the stake property line item was filled out. Since this complaint was filed, respondent's attorney has provided me with a corrected purchase order that shows, let's see. Hold on. First of all, the respondent denied that they were doing any kind of land surveying services. They were not staking property lines, that they would contact this company and have it corrections made. I'm trying to find what that, let's see. Sorry, this is the only complaint I didn't make it to summarize for you.
I see that in your.
Okay,
here.
I'm trying to find it.
It's in the last
I got
paragraph
it
at the
very
top.
recently, so I was like, did I even update this? They gave it to me at the last minute.
No, it's here. Respondent provided a few sentences as an explanation to the complaint stating, I can assure you that no stake property lines has occurred presently or in the past by any employee of our company.
And basically what they did provide is a chalk layout based on control points which had been staked by a licensed land surveyor. And of course, the respondent argues that this was filed just because of personal animosity. But after reviewing everything, after getting the corrected purchase order, I don't have any proof of any kind of violations. I mean, the purchase order was changed, so, and that's all we ever had.
We never got the original purchase order that outlined these things?
Right, but it was just an initial draft. It wasn't an invoice. I got a corrected invoice and a corrected purchase order that stated, that's what I'm trying to find here.
Right.
So the updated purchase order and final invoice clarified the work was just for construction layout services, not for a property line survey. So any reference to land surveying was removed. It was literally a completely different purchase order. The respondent kind of argues that this construction company made the mistake. They didn't create this purchase order. It was a construction company that had a misunderstanding as to how important it is to not put that on a purchase order when it's not a licensed land surveyor.
Do I understand this last one right here when I read this say that, no, I wasn't staking property lines, I was merely chalking where the surveyor would have put the property line.
Yes, that is what the respondent stated the actual work was. It's towards the bottom, bottom half of the last paragraph.
Respondent only provided a chalk layout based on control points staked by a licensed surveyor.
State by licensed surveyor, okay.
And I guess is he saying the chalk layout of the building or structure they were doing as opposed to, I guess that's where kind of hits me. I assume that's what he's saying, that he's not saying that he went out and chalked where the property line was.
Correct.
Okay.
Yeah, I don't think that's what he's saying.
All right.
Would this be a situation for a letter of instruction? Just as a clarification here, it kind of smells of, we kind of offered this stuff until we got caught.
Well,
And then all of a sudden I'm going to fix that. I'm going to fix it and submit it and say, this is what I've done all the time.
I guess
Yeah.
I don't know how the respondent would have control over what their client is typing up on a purchase order. I don't have any proof that they're offering any land surveying services. It just seemed like it was a mistake on the behalf of their client.
On the client, okay.
Yeah.
My bad, I missed
This
that.
construction company typed up this purchase order and they had no control over.
I'm with you.
that.
Okay. Yep.
Now, if I wouldn't have gotten a corrected one, there'd be a problem. But I got one.
Yep.
It might still be fishy, but I just don't have any proof of that.
Okay, I see that. That clarification in the first part here.
I had a question. The reference to control points, is that surveyor lingo for specifically something or?
It is. What I envision happening here is because there's a lot of contractors who will, the architectural plans they get for, say, a house will show layout dimensions off of the property line. Well, that's what they have, then they have to have a surveyor actually do the layout because it's touching the property line, coming off the property line. However, if the surveyor comes out and from the property line either sets the corners or gives the contractor control points that he can now work off of that ensures that he's not violating a setback or anything, that would be the proper way to do it. And I can see where the purchase order would get confused just because they didn't understand that level of complexity, that if you say boundary survey, that someone like us are going to say boundary survey. That means something to us.
It seems like they used the wrong template, basically.
All right, do we have a motion?
Motion to dismiss?
Got a motion from Mr. Kaufman. Do we have a second?
I second.
Got a second from Mr. Martin. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none. That one is approved, and I don't believe there's any more.
There is
All
not.
right,
Thank
good
you
job,
for
Erica.
suffering through that with me and for reading all of that exciting detail when you
Yeah.
got this report.
Yeah, good deal. All right. Is there anything else from legal?
Not for me. I think we had a decision on this. But.
Very good. All right. Thank you, legal. I appreciate your support leading up to this meeting and thereafter. I knew that one was a doozy. Erica warned me, and then when I saw it, I realized she was telling the truth. So I think, and that seemed to work well. For that to be our tester, that was a pretty good test, the trial run. I think that was, I think we dived into all that we needed to, while at the same time too, not duplicating that effort by reading it as well. And I think we accomplished what we need to accomplish. So, unless there's, obviously there's freedom, but we'll just continue that template forward and go from there. All right, thank y'all. Looks like we're ready then for new business. Do we have any new business before we get to public comment?
Hearing none.
All right.
I guess because we went over reciprocity already.
Yep. So all we have left is public comment and adjournment. For one, can I just bring up one, just sort of it's really an announcement. It's not really new business. But Heidi, I should be embarrassed that I'm pointing her out, but Heidi Overstreet over there, this is her last day will be June the 2nd. So she is leaving the Commerce and Insurance And, we're seeking, she's helping right now pick her replacement. So we're going to, we're going through that process now. We're going to miss her. And so we're going to love on her today because this is our last all-in day with the staff meeting. And she's been a tremendous help to me and to our team. So she'll thoroughly be missed, and I know each of the boards as well. So you're the last board meeting she has, so you have that privilege and honor. I don't even know that we were able to say anything to A&E because it just sort of was moving along, and we weren't sure. We didn't have a date yet, but unfortunately, I'll have to let them know after the fact. But so yeah, you're the first to know. Anyway, thank you, Heidi. Yeah. All right, good deal. So I think we're ready for public comment, and so let me just run down through our list. Yep. So let me check here first in the building. We don't have anyone else. We've already handled Lawrence, but I do believe we have some public comments on the screen. Jimmy Cleveland, are you still there? Did you want to approach or say anything to the board? Okay.
Yes, sir. I just wanted to, I appreciate the opportunity to ask a question. In referring to the discussion on the principal in charge and filing the firm disclosure, a couple of our firm was recently, I'm the principal in charge for THY Incorporated. We're out of the Memphis area, and our firm was recently acquired by OHM Advisors, who holds, we've got offices in multiple states, and there, of course, we've got multiple surveyors throughout the state, and recently had some more surveyors come on board. So the principal in charge, of course, is a concern. And then also as we transition, combining two corporations is a lengthy process. And I just want to make sure that I'm not going to be in trouble because I am a principal of the company. But I want to make sure that I'm not going to be in trouble because some of our contracts are still with THY. Some of our newer contracts are with OHM out of the Memphis office. So I just want to make sure, I don't know if I need to file something with the board to make sure that to explain the situation, because I want to do everything by the book, but we also have to continue to conduct business and take care of our clients and just make sure we're following all the rules with proper notifications.
Yeah, no, that's great. I appreciate your due diligence and your concern in that regard. And two things for specifically, if you would just send that in writing, your request and your inquiry to writing to the board, you send that to me or to Phil, CCing me, then we can do our due diligence and check to see exactly what the case is. We don't typically weigh into hypotheticals because there could be variances or mitigating, aggravating circumstances. So there's particulars all up in there that, if we would not litigate or make a decision without all those particulars. So, and that starts with a written inquiry. So, yeah, just send that our way. We'll take a look at it and we'll give you an answer.
Okay, I appreciate that. Just for informational purposes, I've notified the Mississippi board as well. We've got both THY and OHM have a COA in Mississippi, and they just made a notation of it that we were working through a transition process, and that once the transition process was over, just to let them know, and they would remove my name from the THY that will eventually be dissolved. So yeah. I just want to make sure that we're following the rules and doing what we're supposed to do, especially going from a one person or a one survey principal firm to a firm that's got multiple surveyors in Tennessee. We just want to make sure we're following the rules and doing what we're supposed to do. So, yeah.
And we've got a rulemaking hearing as well next. We hope next meeting. Kyle might open field tackle me for making that kind of a commitment on the record. But so we're hoping to do a rulemaking hearing in August. We've got some retrospective rules that touch on some of these issues that just provide some clarity, so a cleanup, further cleanup. So. I think that'll really provide some assistance in that regard. And that was my second piece on a more higher level, but. And then of course, we may have a rule package subsequent to that after the fact once we clear that hurdle. But so ongoing conversations about that, always looking for ways that we can do that better and more clearly and concisely communicate that to our licensee pool in the industry. But yeah, just as to your particulars, just send me a written inquiry and then we'll respond.
Okay, thank you so much. I appreciate the opportunity to present this to the board.
All right, thank you, Jimmy.
Hey, Glenn, could I expand
you.
on that just a little bit? I would think with the information he provided and for any other, maybe company mergers of some sort that people may be listening about, I would think that, and I believe the way it reads is the firm disclosure must be updated anytime there's a change in the officers or principals of the firm. Obviously, this is an acquisition. The firm has changed. I would think that alone would trigger the requirement for filing an updated disclosure.
Okay.
Yeah, and the
Okay, well, I'll
disclosure itself
definitely-
lists all of the reasons you would need to file an updated one and gives you the time frame. So I highly recommend you look at that right away.
Okay, we'll get that taken care of.
Yeah. It gets tricky, and the reason why I mentioned the difference between hypotheticals and otherwise is because sometimes you don't have a true merger. You have DBAs and you have
That's what I was gonna
holdings,
say.
and
Yeah.
that's why.
If
and
the
that's
original
why
firm is a wholly owned subsidiary of the new firm,
Yes.
now you're getting into
we didn't really change
that
anything.
company
Right.
didn't change.
Correct. And so you nailed it, and that's where I was going. That's why we don't do hypotheticals.
Yeah.
I need a written, in front of me so I can break it down, look at it, compare it to the rules. Yep. We
There's
don't
a
shoot from the hip.
Huge decision tree coming out.
Yep. You bet. Thank you for highlighting that. I appreciate it. All right. So Daniel Smith, are you on there still? Did he want it? Okay.
Hey, how's it going? You guys hear me okay?
Yes, sir.
Awesome. So my name is Daniel Smith. My father is Land Surveyor Tommy Smith. His number's 2012, and my grandfather is Rocky Montoya. He's license number 697. I've grown up doing land surveying for a while. When I originally started doing land surveying work was in 2016. I started working for my father full time. At that point, I believe that there was an option to have a 10-year work path to licensure. I believe it was then later updated that same year. And I was curious what the requirements would be now. I attempted to find out all the requirements myself, but like Lawrence earlier, there's a couple of different documents that I've read on the Tennessee Gov website that left some ambiguity as to what my path would need to be to acquire a state license. And so I was just hoping to have some clarification from you guys on what it is that I need to do. I'm at the 9.5 years right now. In January, I will have done 10 years of consistent land surveying. So I would like to get my license in the near future, but I wanted to kind of get in front of it and make sure that I understand what the requirements are going to be in my situation.
I would like to direct you to TCA 62-18-109. There's a lot, but there isn't. It's a if a lot of folks when they go into it, they'll borrow from different areas of the statute or from the rules to create a separate pathway that doesn't exist. But the best way to read that, the most simplest way to read that, and of course I'll allow Kyle to jump anytime he wants. But TCA 62-18-109 prescribes what those pathways are. There's 5, and so as you go through that, you'll be able to find from what it sounds like you're going the experience pathway. That'd be pathway number 5. But
Correct.
Yep. And so if you go to TCA 62-18-109, pathway number 5, scroll your way to the bottom, that'll really roll it out. And if you have any questions, then just in writing to me, and then we can respond to that.
And I would just add, our website does list those education requirements. That would also be a tool for you to go and look which one may apply.
Okay. I have a follow-up question then, if that's okay. Would the continuing education seminars be applicable for the coursework, or does it need to be coursework at like a university of some kind?
Yeah. So again, that's you're getting into particulars, but no, just out of the gate, no. Qualifying education, it says board approved coursework, which would be college work.
Okay. And then do I need to be holding a PLSIT currently, or is it just a 10-year? Because it says progressive.
You have to have the professional land surveyor in training prior to getting the PLS, the official licensure. Yes. So you would at some point you would have to get a PLS-IT, then the PLS. It may not, may not be for an extended period of time, but you do have to have it before, prior to. Yep, the statute does read
Okay,
that way. Yep.
but I don't have to have it for 10 years is what I wasn't sure when the practical
That's correct. That's
progressive
correct.
experience.
Yes,
Okay.
sir. Yep.
Okay, awesome. Well, thank you so much. I think that actually does answer all my questions that I had, so I really appreciate it.
Sure. Thank you for calling in. And then Justin Smallwood. Oh, sure. Yep.
I want to add something real quick, just for information. Remember last year, a year and a half ago, there was a public chapter that was passed that revised the rules for categories 4 and 5. And I know that some of the websites, if you type in, go to those particular TCA 119, or 109, excuse me, are not updated and don't reflect the recent chapter that was passed.
Yeah, it wouldn't be
about a year and a
ours.
half ago, so
But yeah, so
Just
yeah, you
making
do
sure.
need to dial it in. Chapter 650, the Department of Secretary of State's office has updated our official websites that link it to that site. So that would be correct. But yeah, I would go to tn.gov/reg boards and then find land surveyor from there, and then you'll get the correct link. But laws and rules, and it'll take you LexisNexis. If you go LexisNexis, you'll get it right. But sometimes you go to some websites, AI, you know what I mean? And they take you to some sort of, pre-capture that you might get stuff jammed up. But you do need to go to an official website or a link that would be LexisNexis or Secretary of State's office who does the filing, or from our website, which links you to both. Thank you for that
Understood.
comment.
Thank
Yep.
you.
And then Justin Smallwood, are you there?
Yeah. Can everyone hear me?
Yes, sir.
All right. I've got a similar issue as Mr. Smith and Mr. Lawrence. Give you a little background. I've been surveying since 2008. In 2021, I graduated from Chattanooga State Community College with an associate's in construction engineering. And I am currently have an application to upgrade from LSIT to a PLS, doing Pathway 5. And I got a deficiency letter, and one of the issues, it states for Pathway 5, 18 hours of upper level List 1 courses are required. Please resubmit your course log with 18 hours of upper level courses. And then when I look at TCA 109, it says Pathway 5 will be required to submit 18 hours of courses related directly to surveying. To expedite your application, the board suggests the 18 hours be equivalent to courses shown in List 1. So my question is, how do I get information on what courses I have and semester hours are going to work?
Yeah, the board meeting is not the forum to adjudicate personal sort of applications, because we don't have those applications for us. If it was on the agenda, it would say application review, and then we would get into particulars of each of those cases. So again, I can't speak to hypotheticals. I don't know. I haven't looked at your application. Not familiar where those deficiencies are, what the deficiency letter said, if you submitted an application or not. But we would have to, that kind of inquiry would happen during a just directly to the board, for which we would provide a response. Generally speaking, to your point, you did talk about the coursework. That's 18 hours. That would be, it says board approved coursework. And so really it's a coursework, which is college courses. It does not necessarily require 18 hours. However, the board has the discretion, board-approved coursework, to exercise that. The statute does not strictly say that, however, in the sense that you have to do 18. It does say 18 hours, so you have to do 18 hours in college work. It also says board-approved. So the board-approved would be two licensed land surveyors sitting on the board making a decision that satisfies. The expedition is what you're talking about, is 18 hours upper level. They do have some discretion. Doesn't all have to be upper level courses, but they, if the board decides and exercising their discretion that it's 18 hours, then it still falls within there. So I don't know that if they've looked at your application, if you've submitted one. If you have submitted one, and then and the board members have rejected it, then that would not be board approved coursework at that point, as determined by statute.
So the deficiency letter that I received, does that mean that the board hasn't reviewed my application
No,
yet?
again, I don't have your application from me. Did you, so you applied then?
Right.
Okay. And then, so
Yes, yes.
you received a deficiency letter. So I assume that the board, at that point, they would have had to have looked at it for you to get a deficiency letter. That would be is that the case? No? All right. So you didn't? Okay, yeah, so, okay. Yeah, and so just if you could forward that to me, that inquiry, I can look into it and reply to you. But that's not really at all what the public comment section is for, is to litigate, all the application issues.
I'm
Yep.
sorry about that.
No, it's okay. Thank you for calling. Did you have any other additional just follow-up questions related to items pertaining to the agenda?
No, thank you. I'm
Okay.
sorry, but what's your name? Who do I send
It's
it to?
you can send it to Glenn.Kopchak, Kopchak @tn.gov. That's Glenn, GLENN.KOPCHAK @tn.gov. There's also and that I can move along for you, or to Philip Lecco, but that you can do that direct, or just send it to the board, the general website. That gets processed accordingly as well. So I'm not trying to invite every inquiry to my personal inbox, but at the same time too, if you reach out to the website, you will see a general board, and they'll take it right to where you need to go.
Okay, thank you so much.
Yeah, you bet. Thanks, Mr. Smallwood, for calling. Do we have any other folks online? All right, great. Hearing none, then it looks like, Chair, we are free to adjourn if you so choose.
If I remember correctly, we've got to decide how many hours of credit
Yes,
we get
thank
for
you.
this.
Yeah, it looks like, let's see where we're at. We're at 11 o'clock, so that's be 2 hours in. Just need a motion in that regard.
Motion for 2 PDHs for 2 hours of service.
All right, thank you, Mr. Kaufman. We got a motion in that regard. Do we have a second?
A second.
Got a second for Mr. Martin. All in favor, please say aye.
Aye.
All right. Any opposed? All right, hearing none, that is approved. And Chair, it's up to you.
And then, let's see, do we need a motion to adjourn?
No,
or
sir.
just declare we're adjourned?
Since we have the agenda,
We're
you can.
adjourned.
All right, we're adjourned then. Thank you, sir. All right.